sir. Yes, sir.
Good morning, Paul, sir. Thank you for joining. So, good morning, everyone. Thank you for joining in.
Morning, sir. Morning, sir.
Good morning.
Pardon, sir.
Good morning, sir.
Sir, morning, sir. Arun, sir. Morning, sir. Morning, sir.
Yeah, good morning. So, we thank all the participants for joining in. So, Naveen, sir, I'm really happy to share that we have members from across India who have joined in. So, Paul sir is from Coimbatore, Arpit ji is from Jodhpur. Then Annapurna ma'am, you must be, she's your co-author. So, Akash ji is again from Jodhpur. So, Gaurav ji is there from Gujarat. Girish Kulkarni from Kolhapur. Padmanathan ji from Kerala. Soumya ji from Bangalore. Suyada ma'am also from Bangalore. So, we are just waiting for other participants to join in. Good morning, Gurjit sir. So, Gurjit sir has also joined us, who is the speaker for the second session. Thank you, sir, for joining. Venu is also joined. He's in the middle of.
Yes, sir. Good morning. Thanks for your wishes. And audience now for the first part.
Yes, yes. Thank you, sir. So, we're just 2 minutes away. We'll just wait. I think. Yeah. So, moderator for the day, S.K. Malhotra sir, is also joining. Malhotra sir, good morning and thank you for joining.
Very good morning, sir.
Good morning. So today, I'm very happy to share that Malhotra sir will be the MOC for the day, the MC for the day. So he's a moderator. He's taken on this responsibility. He's volunteered for this responsibility. So really thankful to you, sir, for volunteering for this responsibility of being a moderator. And we thought जम्मू से moderator होंगे तो अच्छा होगा क्योंकि थोड़ा बहुत frequent आएगा वहाँ.
Thank you, sir. Thank you for good words for Jammu. Today it's
Yes.
raining in Jammu. It's really
अच्छा.
it's so pleasant after a long spell of summer hotness.
अच्छा. So that's good. That's good. So we welcome all the participants to today's session. So I would now hand over the entire deliberation to. Before just handing over, I would request Arpit ji and Venu ji to just share quickly about the purpose of today's session, maybe in 1 minute. Arpit ji, you want to share?
A very good morning to all.
Or-
And as
Yes.
we stand at GST at 7, so it's a very momentous occasion which we are seeking. And as you all know, 1st July 2017 was the day when GST was implemented Yeah, in the past, in the last year on 1st of July, we had a great program. So in continuation with the earlier program, we have today organized this special session of two of the most coveted speakers, and we look forward for gaining knowledge from them, and hopefully it would be a great session.
Thank you, Arpit ji. Thank you. Venuji, would you like to have some quick words? I know you're in the seminar, maybe.
No. It's actually great to hear from our own fraternity group, and all the best to all of us GST ke saath saath.
Thank you. Thank you. So, Malhotra sir, now the dice is all yours for the next 2 hours. So, over to you.
Thanks you, Aroopji. Thank you very much. Before welcoming you all, I express my sincere gratitudes to the organizers for making me a part of this prestigious meet on the completion of 7 years of GST. So, ladies and gentlemen, I welcome you all in GST ke saath saath. On 1st of next month, 8th year of implementation of GST will commence. Though 7 years of GST are over, taxpayers, their consultants, and departmental officers are still struggling to find the simplicity and goodness of this simple and good tax. The adamant revenue mindedness of please, I think mute yourself, please. The adamant revenue mindedness of the departmental officers have been the major cause for suffering to the taxpayers due to uncertainty, heavy rate of interest, and unnecessary litigation. Thanks God, after 7 years, the government has issued clarification on various contentious issues by issuing 16 circulars on a single day. We have been without a tribunal during these 7 years. I know it is quite hopeful that tribunal will finally see the light of the day in this 8th year, and it will make us all busy. Special welcome to the speakers of the day, Advocate K.S. Naveen Kumar from Bengaluru, and our own faculty group member, CA Shri Gurjeet Singh Bullar from Delhi. Advocate K.S. Naveen Kumar will be taking first technical session on appeals before GSTAT. When, why, and how. When, why, and how. He is a practicing GST and indirect tax consultant, advocate, and he is in the field since 2001 and regularly appeared before various forums, including Supreme Court, High Court, CSTAT, and NCLT. Besides, he also provides advisory and representative services in insolvency, SEBI, and commercial court matters. Sir, I am also an insolvency professional, so I can see that how difficult it is to represent in that. Anyway, because I think insolvency, IBC is also, I think, 7-8 years old only. It was only 2017 only when it started. Huh? Anyway, so Mr. Naveen K.S. Kumar, sorry, Advocate K.S. Naveen Kumar has served as co-chairman of GST Committee of Federation of Karnataka Chambers of Commerce and Industry, FICCI. Presented papers on indirect taxes, including GST and other topics across the country in many seminars, conferences organized by ICI, ICSI, FK, CCI, CAE, IMB. Sir, it is really lost. A lot goes to his brief, so-called brief resume, but I think paucity of time. So I will just not come between you and the listeners. So kindly you start your deliberation, sir. Thank you very much.
Thank you, sir. I'm really happy to be part of this elite group where I see many eminent faculties and also authors from across the country. So this is the possibility of GST, where we have the moderator from Jammu, Malhotra ji, and the next speaker is from Delhi, Mr. Gurjit Singh, and Arup is sitting in a train, Vande Bharat, and my friends across the country, they are also present. So it's an important topic. Therefore, and the time also is 1 hour. Therefore, I thought that I should address more on the practical aspect rather than discussing on the mantra part as to what is the provision and what is the appeal duration, etc. I would skip many of those things. In fact, when I was discussing with Arup ji yesterday, he was saying that participants wanted me to address on more on the how to represent before the GS Stat. Of course, I'll be drawing from my experience of appearing before the tribunals, SSTAT and other forums all these years and share my experience. Now that this particular session, the title has been given as GST Case Saath. So we are commemorating completion of 7 wonderful years. Of course, some of them are still in Sade Saath. So they are yet to come out of various problems which people have encountered all these years. And there seems to be some light at the end of the tunnel, as Malhotra ji also pointed out. Suddenly, they have woken up to several inconsistencies and infirmities in the law and trying to bring out certain amendments and also bring out certain clarifications. Unfortunately, GST has become a law of exceptions. Not in an exceptional sense, but the law is made for exceptions. That is not a good trend insofar as any law is concerned. Because when you address the exceptions, then you are causing trouble for the mainstream. So hopefully the vision will change after these 7 years. Hope for the best in the budget. Let me share my PPT which I have prepared for this session. Tell me whether you can see the PPT. Are you able to see that?
Yes, sir. Yes.
Thank you.
Yes, sir. Sir,
The topic itself is very
sir,
interesting. Yes,
sir,
sir.
may I add something that I think this deliberation should continue till 9:50 or 9:55 at the most. Then 5 minutes we will be giving for the question answer session.
Sure, sure. I have kept some time for that also.
Thank you, sir.
You can alert me as we are reaching 9:40, because initially starting trouble is there for speakers, but once we start, stopping trouble also comes. So as a moderator, I would request you to alert me when we reach 9:40 so that I can adjust.
I will do that, sir. I will do that. Thank you, sir.
Thank you. The session itself is very interestingly coined. I have been asked to deliberate on when, why, and how of appeals to the GS Stat, which I would do. So the intention is to briefly touch upon the appellate remedy and what is the status of tribunal under law, what are the appealable orders, when to file, why to file an appeal, how to file and appear. So I would focus more on the how to file and appear so that I can share some insights on my experience appearing before the tribunals. As we all know, this is in the GST context, we have the first appellate remedy, which most of us have exercised at some point of time. And we have got sufficient experience in the last 7 years. Second appeal is GS Stat, which is yet to start. I think the GST law has the dubious distinction of not having a second appellate remedy. This I have never come across in any law. Therefore, I would feel that the development of law has been hampered because many issues, interpretational issues, which could have been dealt with by the tribunal, have not been, we have not been able to address those issues, leading to a lot of litigation and uncertainty in the law. Hopefully, after the GST comes, we will be able to come out with more issues. For example, what is supply has to be first understood. That is the basic taxable event. Like in the context of the excise law, there was a lot of debate on what is manufacture. That itself took so many years. So here in the GST context also, I'm sure we will have good interpretation issues on what is supply, what is the scope of supply, what is service. All these loose expressions have to be first dealt with so as to understand the nuances of the law. Then, as we all know, the tribunal is always the final fact-finding authority. Therefore, as counsel, we should be very careful in ensuring that all the facts and evidence are brought on record, because when it goes to the next stage, that is the High Court or Supreme Court, then those issues are only pertaining to the questions of law. So therefore, when we represent before the tribunal, we should ensure that all facts are brought on record. Then as far as the pre-deposit requirement, 30% was always higher. So therefore, there is some thought process to bring down that amount. We have a good example in the form of the Sestat, where in the old regime, we had the 7.5% and later on balance 2.5%. And it has been working quite well before the tribunal, not much of resistance. So if 30%, if it was continued, then it would have been a big burden for the litigants, considering the fact that during the initial days of the GST, the litigation is going to be more. And now they are also looking at the monetary limits. But one thing which I noticed was the monetary limit, which is fixed, proposed to be fixed for the national litigation policy. It is lesser as compared to what is there for Sestat. Hopefully, they will increase it as time passes. Then basically, we are looking at orders from the appellate stage, first appellate stage and revisional authority, so that we can file an appeal to the GST. The time limit has been prescribed. Interestingly, if you look at the provision, in the context of Sestat, there is no upper time limit for the tribunal to condone. But in GST, there seems to be an upper limit, like what you have for a condonable limit for the first appeal stage. We have it for even the GST. So we should be extremely careful when we accept briefs from the litigants so that the appeals are filed on time. There have been debates on the powers of the court, High Court, to condone the time limit which is prescribed in law. There have been decisions of the Calcutta High Court recently where they said Limitation Act can be applied. Of course, we have Supreme Court judgments in the context of old law, Singh Enterprises, Hongo India, etc., where the court has said the writ court cannot extend something which is not prescribed in the law. So this is an issue which is going to be debated across the country. But to be on the safer side, it is better to file the appeal on time. Hopefully, it will be online. The portal may be activated very shortly. Then, of course, till now, since the GST was not there, removal of difficulties order was issued. Although they said that we found cases where the department was taking coercive action and people were driven to the courts to seek relief, interim stay, etc. Many matters have gone to High Court where interim orders have been passed, and once the tribunal is constituted, those matters will be transferred to the tribunal, where the High Court will say that you go and file an appeal within the time limit prescribed. And some matters, the people have made the mandatory deposit expecting that the department will not take any action. And some cases, the action has been withdrawn once the mandatory deposit of 20% was made. Now that some changes are proposed in the mandatory deposit, a question will arise whether if there is excess deposit, will it be refunded? We have to see how the mechanism is going to work. Then in some matters, the department has fully recovered the amounts, or where people were not certain about their stand, they have also deposited the full amount and they are contesting those cases. So as of now, there is no remedy in the form of appeal to tribunal. It will come shortly. My view is that now that the GST tribunal has got some momentum, we should keep all the appeals ready so that there may be many matters which may be kept separately, expecting the tribunal to be constituted. So we will not have much time after the tribunal starts functioning. So we have to get ready with all those matters, keep it ready, and then file it as soon as the tribunal is constituted. Before that, when to file? So now itself we can get ready with all those matters. There is no need to wait for the notification or the structure to come. According to me, it will take at least 6 months for the tribunal to start functioning, because you have to appoint the members. Till now, there is no news. Only the president has assumed charge, and you need manpower, you need infrastructure. To create that infrastructure, it takes a lot of time. So I don't see a possibility of the tribunal starting the proceedings before 1st January of 2025. Now, there are many issues which have gone to the writ courts on constitutionality or virus of the provisions. Those type of matters cannot be agitated before the tribunal. So wherever the provisions are challenged or notifications are challenged, then it is better to pursue the remedy before the High Court. Because the tribunal, being a statutory creature, cannot go into the constitutionality or virus of provisions or rules or circulars. It has its own limitation. Therefore, those matters will still be with the High Court. Then why should we file an appeal? If you look at the provision, the statutory remedy is there. It is an effective remedy. And if you look at the experience in the context of SESTAT, most of the matters, I would say that at least 90 or to 95% of the matters get resolved at the tribunal stage. And if you look at the statistics which have been published, the department would lose at least 90% of the cases before the tribunal. So the success rate of litigants, the tax litigants, is more before the tribunal. Of course, 5% of the cases, the assessees would in any case lose. So those cases, the department has succeeded. So even the GSTAT is supposed to function in the same manner, in an independent manner. There were apprehensions expressed in the past. Matters went to the Madras High Court and then to the Supreme Court. The provisions were challenged, and some remedial measures have been brought forward, which probably will bring GSTAT on par with the SESTAT. So the remedy is supposed to be effective, quicker, and speedier. More importantly, the costs will be less. Litigation cost will be lesser as compared to the litigation cost which you may incur before the High Court or Supreme Court. Of course, the writ remedy has inherent limitations. Even the Supreme Court has time and again laid down the parameters under which writ remedy can be exercised. Therefore, the tribunal is supposed to be, once it becomes functional, it is supposed to settle many of the pending issues which have surfaced in the context of GST law. Of course, we have the departmental authorities who will do whatever they are supposed to do. And when the matters go to the tribunal stage, I see that many of the issues will be sorted out. And the tribunal can also address the recurring issues in the context of GST. Once a precedent is laid down for one particular issue, then since we have a common law across the country, we have a lot of precedents from different benches of the tribunal, so which will sort out many issues. Now, I will come to the practical aspects of how to file appeal before the tribunal and appearance. As a council, we are always judged by our draft and also the appearance before the tribunal. Therefore, our communication, either written or verbal, becomes very important. So we have to hone our skills on drafting or relating to appearance before the tribunal. So, in fact, I remember I had conducted one session only on those two aspects some time back. So, how to develop your own way of presentation, either in writing or in the form of representation, appearance before the tribunal. So, these are some aspects which I would touch upon. More importantly, I would also look at the do's and don'ts, sharing from my own experience, and also looking at others' experience. In fact, you can learn when you look at mistakes committed by others instead of we ourselves committing mistakes. In fact, at the end of the session, I would also point out the way forward, how you can start this process of appearance right now, although the tribunal has not come, how we can prepare ourselves for appearance before the tribunal. I would reserve that for the last slide. Now, before I go to the practical aspects, there are some common issues. Some of you might have thought of it and would have raised it at the end of the session during the Q&A, but I'm just preempting some of those issues. For example, some people were asking whether the time limit has already started because the president has assumed office. That is what they had said in the removal of difficulty order. But in the latest GST Council minutes, they have recommended that the timelines will be extended. So that has given some relief. What happens to cases where people don't have money to pre-deposit? Can the tribunal waive or can you file a stay application before the tribunal? Because it's a mandatory pre-deposit. Tribunal being a statutory creature, they cannot waive the pre-deposit or they cannot give any remedy on this aspect. Therefore, the only remedy would be to approach the High Court, and the High Court has interfered in some exceptional cases where sufficient cause is shown, but it cannot happen in a routine manner. Even in the context of the tribunal and VAT, we have seen that many times the High Courts have not interfered. So therefore, the litigant has to beg, borrow. I would not recommend steal. So he has to somehow mobilize the resources and make the pre-deposit. Of course, in some cases, the High Court may say you give some more time for them to pre-deposit. That type of indulgence may be possible, but not a complete waiver of pre-deposit. And there are instances where the condonable period has lapsed. So in those cases, what is the remedy? Suppose you file an appeal before the first appellate authority beyond the condonable period. The appellate authority is going to reject it. Or similar thing may happen before the GSTAT once it is constituted. So in those cases, you may have to look at a writ remedy and use those precedents, particularly the Calcutta High Court judgment, S.K. Chakraborty and other judgments, where they say even limitation law will apply. And of course, we will be confronted with the Supreme Court judgments in Singh Enterprises and Hongo, India, where they say that the writ court cannot extend the time limits. So this is a debate which is going to continue in the future. Let us hope that something transpires in the context of GST law. Now, the other thing is, what is the remedy against coercive action? There are instances where the department has invoked the provisions of Section 78, although the time limit to file an appeal has not expired. In those cases also, the party has to probably make a pre-deposit, that mandatory pre-deposit, and inform the department. If they don't withdraw the coercive action, the only remedy would be to go to the High Court, parallelly expedite filing of appeal, so that they can always tell the High Court that they are in the process of filing an appeal. Therefore, they should not, the department should refrain from coercive action. Then when it comes to mandatory deposit, I've already addressed this issue. Can it be waived or reduced? It would be a discretionary power of the High Court, but I feel that the court may not interfere in many cases. Then I was also asked to address on this point, distribution of work between the principal bench and other benches. These things will be addressed when the rules are placed on, when the GSTAT rules are framed. So it is a premature question to answer at this stage. I just leave it at that. It also depends on how many benches come. And in some states, there may be more than one bench. All these things will be known only after the tribunal starts functioning. Then how to prepare for tribunal practice, I will address. How many adjournments? The law says not more than 3, but there is one Delhi High Court judgment which says that it is not a matter of routine that you can take 3 adjournments. They say that you should give sufficient cause and then only adjournment is possible. So it is not a matter of right. Then the power of remand, the first appellate authority has no power of remand, but I don't see any embargo on the tribunal. It can send matters back to the lower authorities. Then can you urge fresh grounds or evidence? The law is settled that any question of law can be urged before the tribunal for the first time. You have many precedents in the past, like NTPC case or Jude Corporation. It is settled position of law. And there are rules regarding filing of additional evidence. There is an application which will be required to be filed, and there's a set criteria in the rule which has to be followed. But the litigant should attempt to file all grounds, all possible grounds, and all possible evidence should be brought on record. Because when you go to the next stage, which will be the High Court or Supreme Court, they will not entertain any new grounds or evidence. It will be too late in the day to urge new grounds or bring in new facts or evidence. So whatever is possible, create a good foundation so that it will be taken care by the tribunal. Then before the High Court or Supreme Court, you address only on questions of law, because the tribunal is the final fact-finding authority. And what about the amount paid during investigation, whether it can be treated as pre-deposit? There are precedents in the past. Hopefully it will be considered in GST also. Litigation policy has come, although the limits are less for GSTAT as compared to what is there for SUSTAT. And authorized representative who can appear, a CA, practicing CA can appear, advocate can appear, even the party can appear in person. These are all set out in the law. Now let us look at the do's and don'ts in the tribunal and appeals. I wanted to share some points from my own experience. As we all know, first appellate authority stage and GS Stat, a CA can appear, but before the High Court or Supreme Court, only advocates can appear because it's a court of law. And to make a beginning, some people would have an apprehension that I have never appeared before any tribunal, whether it is ITAT or SESTAT or NCLT or even the VAT tribunals which are there. I don't have any experience at all, even in the past. So how should I make a beginning? One way of looking at is, now that 7 years have passed, you are quite adept in drafting appeals and you also understood the law. Therefore, one can now start with acting as an instructing counsel in matters. An instructing counsel instructs another counsel. He may be a senior CA who has experience in appearing before the tribunal, or the advocate who regularly appears in the tribunals. So you can start as an instructing counsel where you will do the drafting, and even within your own team.
Are you to interrupt, sir?
Yes, sir.
Sir, I think we are on the last page of your presentation. I think you are speaking from the presentation or not? Because
no, I am speaking from the presentation only.
But I think it's here. It's only last page is appearing, sir. Please.
Is it? Okay.
Yes,
shall I share again?
Please. Because it's only last page is appearing on the screen, sir.
Okay, just a minute. Are you able to see it or not?
No. Yes. No, it's
Yes, now.
yes. No, there is as instructing counsel and argue counsel.
Yeah,
that side is there.
Maybe when I put the full screen, it goes off. So let me continue in the same manner.
I hope, sir, you will share this presentation.
Yeah, definitely, sir. I'll send the mail to Arup.
Thank you,
You
sir.
will post it in your groups.
Thank you, sir. Thank you.
Yeah. So the next stage would be to become an arguing counsel. And within your own team, you can have an arguing counsel, one instructing counsel. Instructing counsel prepares the entire material for the case, starting from the drafting of appeal. And then he also researches before the matter comes up before the tribunal and case laws, etc. And he gives the compilation to the arguing counsel, briefs him. So this sort of an arrangement can be thought of. Then you have the pre-hearing preparation. I would always say that facts are very important. So fact marshalling is very important. In fact, I remember one anecdote in the life of Gandhiji, where he was a lawyer who went to South Africa during his early days before he became the freedom fighter. He met a senior advocate there, an attorney, and asked him for advice. The counsel would say that you take care of the facts and the law will take care of itself. That also is my experience. There are some cases where you just explain the facts and issue. The member already knows it and he will not even ask you to argue further, because the tribunal is supposed to be a specialized tribunal with members having experience in the field of taxation, unlike a High Court or Supreme Court where the judges come from a different background. So once you take care of the facts, the law will take care of itself. In many cases, moment you state the facts properly and the issue, the member would have understood it. So fact marshalling is very important. You may have 1,000 pages to look at. So I always recommend that don't skip. Don't read only half of it and leave it. Who knows, you may get something crucial at the end. And that has been my experience also. In going by Murphy's laws, sometimes you find something only at the end of the file which is presented to you. Then you should also do the case law research, the circulars, which are there on the issue, then you should also make notes if possible. Nowadays, we have uh, the gadgets like iPad, where you have liquid text. Some of you might be using it. So since GSTAT is supposed to be e-filing and also the digital form of filing, we may have to get used to it. Therefore, make a note of it in your iPad and sequence your points. Then prepare a compilation. Suppose you have many provisions and case laws to share, it is always better you have a compilation in place so that with the numbering, index, etc., it becomes easier to draw the attention of the members. Otherwise, it becomes very difficult for you and also to them. These are all finer points which we should develop. Then before the hearing, it is always better to prepare a synopsis of submissions which can be presented. And even when you are presenting, the member would like to read those important points which you are urging so that it becomes easier to grasp it and also for dictation. Particularly when the matters are reserved, orders are reserved, these submissions and compilation would be handy. We should also know how the other side is going to present. You should expect you should imagine what is the worst point in your case which they can bring out. Because what is the worst point for you is the best point for the other side. So you should also be in a position to expect. In fact, I remember in one matter which I did in 2004 before Supreme Court, I had thought of one aspect I thought is the weakest link in my case. It was a departmental appeal, and I was hoping that the other side will not bring up. The ASG who appeared in that matter, his first point was that, but I had already prepared my response for that. Therefore, once I said that, the judges were convinced and I was able to succeed. Therefore, you should also think of it. And there are, I have heard that there was one lawyer in Chennai who would create two teams in their office, one for department, another for the assessee. And he would become the judge, listening to them, making notes. So when he went to the court next day, exactly the same points would come up and he was ready with the matter. So these type of approaches can be developed by some of us. And of course, if you are arguing classification matters, etc., then factory visit is a must. I remember in 2004, when I briefed a senior counsel in one matter relating to turbines, the first question which he asked was, have you seen a turbine? My answer was no. Then he said that you should never argue cases on classification without even seeing the product. So therefore, and after that, I went and saw the turbine, brought a video, showed it to him, and we ultimately succeeded in that matter. So seeing the product is also important, particularly when it is classification. Then when you are arguing the cases, you always aim for brevity, simplicity, and clarity. I fondly remember one of my submissions, one of the appearances of my senior who passed away recently, Mr. Ravishankar. It was an excise matter where the stakes were very high and towers were erected. The department would call it as movable goods and they demanded excise on that. So he started off the submission by saying that, my lords, they want to levy excise on Qutub Minar. This is how he started. Then the members asked, what do you say? He said, my tower is bigger than that, firmly erected, it is immovable. And on that, they want to charge excise. Stay was granted within 2 minutes. So how you present it to the tribunal is also important. It's an art which we should all inculcate and have to develop with experience. I'm sure all of us would be able to do it. And we should always bring out the crux of the issue in the first 2 minutes. In fact, your case is judged by the member in the first 2 minutes of your presentation. So you should tell that this is the issue so that they focus. Even if you may narrate 10 facts, but if you don't say what is the issue, they will not be able to connect. So therefore, you should also tell what is the issue. For example, you would say the issue relates to classification of mobile phone, or you would say the issue relates to.
Naveen sir, it is 9:40, sir. Okay, sir.
Yeah, thank you, sir. Thank you. I am on track. So you can you should state the crux of the issue in capsule form. And what is the right way of arguing? There is no right way. Each one has to develop. In fact, it is always a good idea to go and sit in any tribunal. It can be SESTAT. SESTAT is there across the country. In many, there are at least 10 benches where you can go and see the proceedings. It is open to public. You can go to ITAT and see matters just to see how it is presented. You can learn from others' presentation also. Then there is no replacement for hard work. We should all create a great context for tribunal, and we should also remember that our arguments are going to shape the GST law. And going forward, if you see the journals and all the e-journals which are going to be there, you will find that many decisions will be coming from the tribunal across the country. So therefore, the context is we are going to shape the future of GST law. So therefore, our preparation should be deep and we should be able to do a lot of hard work. There is no replacement for that. And each day is going to be an examination. Unlike your CA exam or law exam, which we wrote long back, each day is an examination because you do not know what the judge is going to ask, what the member is going to ask, and what the other side is going to bring on record. So it is going to be exciting also. And what is the result of representation? It is clarity and certainty in law. So as I said, your argument is going to shape the law. Since the tribunal is the final fact-finding authority, we should ensure that all the facts and evidence is brought on record. Now, if you look at how the tribunal is going to function, they will hear the matter, pronounce the orders, sometimes dictate the entire order, only the operative portion. And sometimes they may reserve orders. I expect this to happen in the GST, at least in the initial years. Therefore, don't forget to file the synopsis and compilation. And even after the orders are pronounced, you would be requested to advise on the next course of action, depending on the outcome. There are cases where there may be cases where the appeal is partly allowed. So you may be asked to advise about the next course of action, whether to go to the High Court or accept, or suppose the matter is decided in your favor, what is the next course of action? There may be a requirement of refund, etc. So these are some aspects which needs to be considered. Then if you look at some of the other points, I will come to the do's and don'ts. When you are arguing matters before the tribunal, urge all the points, ensure that it is put on record. You can take new grounds also, because when you drafted the appeal, you might not have thought of all the grounds. Later on, you might have come across something new while reading for some other matter, or some precedent would have come. So those arguments you might not have put. Therefore, there may be a requirement to file an application for admission of new grounds. Don't hesitate to take it. Produce all the evidence. Prepare a proper paper book. I have seen people losing cases because their paper books were so badly done. Have a compilation. Paper book should have index, page numbers. These are all small things, but will have a big impact. It will also irritate the member if the paper book is not done properly. Imagine a case where your page numbers are different from what the tribunal members have. The matter may get adjourned. Your reputation is also at stake. One more important thing is you should also listen to what the members are saying. When you are arguing cases, members want to say something, don't interrupt them. Listen to them, then you can always respond to their query or whatever they have in their mind. Don't stop them. Then you can be persuasive or aggressive depending on the type of case. You cannot argue a condonation matter in an aggressive manner. It should be argued like a mercy petition. Then ensure that you take proper instructions, have conference with the client. Ensure you put the best point first. You might have prepared 50 grounds, but which is the best point that you should be able to judge and put it across. You should also know when to stop. Suppose that the tribunal member is convinced after 2 minutes, there is no need to argue further. Just because you have prepared for 2 hour submission, you need not go on. So you can stop. Be fair to the other side. Ethical practice is also important because that is the most important for our profession. Then dress code. I have seen instances where the counsel is not properly dressed. Hopefully, when the tribunal rules come, they will prescribe the dress code for lawyers. Of course, for lawyers, we all know black coat and band and white shirt, etc. For CAs also it will come. Then how to start the argument. You should also know the psychology of the judge because each judge is different. So they come from a different background. Some points, which point is more appealing to him. So when you go and sit before the tribunal, you will be able to understand. Then facts are sacred, take care of it. Misrepresentation or misleading is completely barred. It also affects your reputation. Next time when you go to the tribunal, they may not fully believe you. So be careful about that. Then some of the don'ts, not looking for binding precedents while preparing for the case. This may damage your case. So do adequate research and rebut the adverse findings in the order. Condonation application should also contain adequate reasons and should be supported by evidence. And if the delay is beyond condonable period, then you may have to look at High Court remedy. If the appeal paper book does not contain the relevant annexures, it is going to affect your presentation, which should be avoided, and ensure it has index and numbering. Then common errors to avoid is not noting the date of receipt of communication. This will decide the time limit. Therefore, there is power in that cover. When you receive the communication, preserve the cover. And even if it is received by mail or posted in the portal, ensure that the dates are properly noted. GST, every day we have to check the portal and mails for any orders. Not taking relevant grounds on merits and legal aspects. This is also a common error which we find. And questions of law arising out of the order may be missed, which will damage the case. And even after that, if you go to High Court or Supreme Court, they would say that you have not urged this point, therefore will not entertain. Do not interrupt the tribunal. Don't be cowed down. Some members may be very aggressive, but we are also of that equal stature. It is not that you are of a lower rank. You assist the court in laying down the law. Do not beat about the bush. Come to the point straight. And you are not there to demonstrate your intellectual capacity or prowess. So what is important there is the result. Don't resort to long drawn arguments. It may irritate the member because the listening capacity of human beings is very less. Avoid voluminous records. And I also kept 10 commandments for advocates. It is equally applicable to chartered accountants. In fact, I would not like to read it, But since I'm going to share, I would request you to go through these 10 commandments, which is very useful. It is abstracted from a book written by Mr. S. Rajaratnam, who was a former income tax appellate tribunal member. And of course, he is no more. But these 10 commandments are very useful for a tax lawyer or a counsel. So have a look at it. Finally, I will come to how to make a beginning. My recommendation is go to the tribunal, ITAT or SUSTAT or NCLT, go to the courts, watch the proceedings and see how the matters are being argued there. What is the mistake made in a particular matter, how to avoid that. You can learn from others' mistake also. And what stops us is our own conversations in the mind. We are the hurdles of our own progress. And therefore, suppose a big matter comes and someone says, please go and do this matter before the tribunal. The first thing which will come in your mind is that I think I'm not good enough to do this. So this conversation is there for everyone, whether a new entrant or an experienced person. The opportunity is the moment you acknowledge that fear and also ignore it and go ahead with the matter, then you will see something which is transformational in your life. So these are some of the points which I wanted to share. Now it is 9:51. I think I have time till 10 o'clock. You can ask any questions which you have on the topics which I have deliberated, including the practical aspects. Some of you may have doubts on that. Over to the moderator.
Sir, there is one question from our member CA Venugopal ji.
Yes, sir.
He's asking that whether these submissions and submissions made in the courts are public documents.
Public documents, see, generally the tribunal does not give a copy of another person's paper book. So I don't think it is a public document. You cannot ask for a copy.
Thank you, sir. Thank you, sir.
But if it is already there in the public domain, for example, when the court dictates an order, they may abstract portions of it. Or when you are arguing cases before the tribunal, in fact, probably Mr. Venu is asking it in the context of confidentiality, where some of the multinationals ask you to sign non-disclosure agreement. So we put a clause there saying that when I argue before the court or tribunal, which is an open forum, then everyone will come to know about it. So how can you say that I cannot disclose whatever evidence is there? It is already put in the form of appeal or writ petition before the court. So you cannot refrain me from disclosing.
That's very nice, sir. That's very nice.
Yes.
Any other question, sir? Any from any other member, sir? Any member can unmute?
Mr. Venu?
Yeah, sir, also if you can throw some light on the paper book submission and synopsis, so how the member should be prepared.
Yeah. See, one thing which I have learned in the last, I joined my senior in 1997. I was with him for 16 years. The paper books always makes a difference. Imagine you are the member, tribunal member, and a paper book is presented to you before the matter is argued. So the moment you have it in your hand, you should feel that, yes, this is something which I should go through. I have seen instances where it is very shabbily done. Some people do it in trace paper. Some people don't do the numbering properly. There are a lot of corrections where they put whitener and do. So all these things don't create an impression. Not that you are going to win the case only on the basis of paper book. but it also has, it can make a difference when your paper book is properly done. So in fact, that takes more time than arguing the matter. Preparation of paper book, let us say there are 2 volumes of about 1,000 pages, then it takes at least a couple of days to arrange all the papers, put the annexures, numbering, etc. Then also ensure that it is properly sequenced. So paper book is very important, and even the submissions, when you go and argue before the tribunal, you will have 50 grounds in your in the appeal paper book, but you will be touching upon only the important points. So you ensure that those important points which you are going to urge or contend or bring it out in the form of arguments, you put it in sequence and also in a brief manner, so that the tribunal member will be able to appreciate it when the matter is being argued. Even after the matters are reserved, it will come in handy. And suppose your arguments are not considered properly, then it becomes a ground for you before the next forum. Because the other forum will ask, High Court will ask, have you taken this ground? So you will be able to show from the synopsis and also your grounds of appeal.
Sir, there is one question from Mr. Amit Agarwal. Is
Yes,
there
please.
a possibility that GSTAT would enable e-hearings?
I think there is an eminent possibility, because the current Chief Justice of India, Justice Chandrachud, has been a pioneer in bringing the IT infrastructure across the courts in the country, and he has been advocating this. Even Supreme Court, you have a hybrid system where you have a physical hearing and also through the e-platform. So this is going to be a phenomenon which is there and which will be there in future also. I think GSTAT will set a trend, new trend. This is what I expect. Not that they are going to completely dispense with physical hearing. To start with, I think we'll have hybrid hearing. In many of the foreign courts, especially in Britain, they have given up this physical hearing. In fact, many courts have been closed because they are operating through e-platform, and some of the courts have dispensed with these oral arguments. Elaborate oral arguments don't happen. So everything is presented in the form of synopsis, and the arguments are very brief. So this type of trend can be expected in the near future. At least after 2-3 years, we'll be moving towards this. I expect it to be hybrid.
Thank you, sir. Thank you. Sir, and you know it's 9:57, and
Yes, sir.
at 10 we will be starting our new second technical session. So any
Yes,
other quick query can be taken. If any member have any query or any guidance,
Yeah. Yeah, Malhotra sir, Soumya ma'am has asked a question.
Yeah.
One more query, sir. Shall I ask?
Yeah, please, Mr. Paul.
Yes, sir. Sir, is it a must it is better to give a written submission after the argument, sir? What is your opinion, sir? Written submission after concluding the oral argument.
See, what happens, I'll tell you practically. When you are preparing for a matter and you are ready with the matter, at that stage itself, it is better to prepare synopsis and also give it to the members at the time of arguments. Suppose you argue the case and they reserve it, unless the court permits, unless the tribunal permits, you will not be able to file the written submissions. But when you present it before the hearing commences, then it will go on record automatically. That will be the difference.
Okay, sir. Thank you, sir. Thank you, sir.
Thank you very much, sir, for this wonderful presentation. Actually, it was really your practical experience through which you have guided all of us. And I think many of us may not have appear before tribunal, and this is going to be help them certainly, sir. And I really, we are on behalf of this faculty group, I really thank you and thank you and thank you all, sir. Thank you very much for your precious time. Thank you very much.
Thank you,
Malhotra
sir.
sir,
Thank you for,
Malhotra sir, I'll just take 30 seconds to just
yes.
say one interesting thing.
Sure.
I had gone for a session where the speaker said that, you know, what is the importance of small things? Like in a white shirt, if a small tomato sauce falls, the white shirt can't be, you know, worn actually. So like that, you have given us many small tips, like about the page numbering, because I had myself faced a situation at tribunal when this thing had happened. So that time I realized what is the importance of all these small things that you have mentioned. So thank you, sir, for mentioning all these small things. I think which will really help us in this.
Sir, I will add that his presentation will help us a lot. His presentation, we will be preserving it, and it is going to be a guide for all of us. Thank you very much, sir. Thank you.
Thank you, sir. Thank you for wonderful listening, and hope it was useful. Thank you so much.
Thank you.
No, sir, we start our second technical session, and which is going to be taken by our own member, own faculty group member, CA Gurjeet Singh Bhullar ji. And sir, he will be speaking on returns kal, aaj or kal. We have seen that in the original scheme, GSTR 3 has gone, IFF has come, quarter return with monthly payment scheme has come, new GSTR 2B has come. You know, there is in future, there is going to be a facility whereby we would be able to revise our GSTR 1. So in all those things, our own faculty member, Bhullar Saab, will be speaking, and I will be, but I am going to say, just giving him his brief profile. Sir, he is a fellow chartered accountant of our institute, and one similarity I am looking from his profile is that I also qualified in 84 and he also qualified in 84. That's really great, sir. So we are almost same number of experience we are having, sir. And just a minute, sir, I think. Yes. So, sir, he is a chartered accountant in practice. He is in direct taxes and indirect taxes matter for 23 years, vast experience. He's providing GST training through GSTN to state government and CBIC officer. That's very wonderful, sir. And he's involved in automobile component manufacturing sector for about 15 years. So he's specializing in automobile components. So he's a recognized indirect tax faculty of our institute. He has addressed certificate and advanced courses of ICI. And sir, with this, I request him to start his session, sir. Thank you very much. Gurjeet ji, please.
Yeah, good morning, everyone. My colleagues here. Thank you, Malhotra sir. Wonderful to know that we are batchmates in a sense. And after the heavy session, that thought-provoking session of GST tribunals, how we should go about, etc. So we'll try to keep this part a little, hopefully a lighter one, not stressing on the brain so much. Before I begin the presentation, in the end, I may forget it. So in the very beginning itself, I'd like to express obligations to our colleagues who are organizing this SMS every week diligently, the efforts which they are putting out. It provides an onus and the responsibility on all members of the groups to participate in these sessions every time. So I request all members who are there to please participate each and every week. All these sessions have been very, very thought-provoking, learning, interaction of views has been happening. This particular line is for those of members who are joined today who may have missed some of the earlier sessions. Yeah. Coming back to the topic for today, okay, we are going to complete 7 years of GST implementation from 2017. in another 2 days. And topic which was shared with me is about returns. And like it has been mentioned by Honorable Malhotra sir, and it mentioned in the flyover, Kal Aaj Aur Kal. So it was decided in discussions with Arupta that instead of giving an overview what actually was thought, how the returns formed out or played out during these past 7 years, we will try to focus on some particular forms, etc., where more of the learning may be there or more focus is required rather than giving an overall view. But I would like to also say, as I share my presentation, I'll allow me to share my presentation. There's a small presentation.
One second, Gurjit sir.
Yes,
Naveen
sir.
sir, you have been made the host. Can you kindly make Gurjit sir co-host, or can you make me the host?
Yeah, my screen sharing is disabled for now.
Yeah, Naveen,
Yes, sir.
sir, can you make me the host? Actually, you have to click on the participants and then
How do I make that?
so you have to click on my name in the participant list.
Okay, just a minute, sir.
Yeah. There's a participant list. You can see my name, and
Yes.
you have to just once you click on the name, it will come as make host or co-host. Anything will do. Host will do. Yeah, or you can make.
I've done
Yes,
it.
thank you. Thank you very much, sir. Thank you. Yes, Gurjit sir, I've made you the co-host.
Okay. I hope my presentation is visible now.
Yes, sir. Now it's perfect. No, it's not. It's coming. Not yet.
Not yet.
No. Yeah.
Yes, sir.
Is it visible now, sir?
Yes, yes.
Yes, sir. Now it's visible. Yes.
Now it's visible. Okay. So before coming to GST returns and forms Kal Aaj Aur Kal, dwelling on the past 7 years, I believe everyone has heard that little story that a boy and girl meet, they get married, they like each other, and they get married. And few years down their lives, the wife says that आप पहले जैसे नहीं रहे, you're not the same person. Well, all these years she was saying, why do you dress like this? Keep your mustache, not keep your mustache. You should eat this. You should. She keeps on changing certain habits of her husband, and a few years down the line says, "आप जैसे पहले जैसे नहीं रहे आप." But hopefully, that as we are progressing with GST, after a few years, we know GST is not like what it was before when it was launched in July 2017, especially the returns part. And few years more down the line, we will say it in an appreciative way. That GST will say for the GST returns that, yeah, returns are not like what they used to be when we started off in 2017. So with that hopes, Kal, Aaj Aur Kal. Like I said, instead of giving an overview, it was decided that we'll focus on certain items. And Kal, Aaj Aur Kal usually means yesterday, today, and tomorrow. But we are going to twist it. We are starting with Kal, the tomorrow, and we'll keep the Kal, the yesterday at the end. So with Kal, the tomorrow, I'll start with a significant addition which is going to be there. That is the GSTR 1A. A new form is being introduced to amend or add records after GSTR 1 has been filed. So when this comes, it is already there in the process. So when it comes, it becomes available on the portal. That taxpayers will be able to amend or even add records in the same month after filing GSTR1. So that means after filing GSTR1, but before filing GSTR3B, if within this time period, a taxpayer recognizes any mistake and they wishes to amend that, or missed any record and they wish to add that, that can be done. So this amended liability after this addition or amendment, that will get auto-populated in 3B. So that means the differences which are there in GSTR1 and 3B, it is hoped that they will get reduced. And we know there is automatic system recognition of the differences and notices, system generated notices come, and then recovery may follow under 79. That all that process is already enabled on the system. System generated notices coming, taxpayers have to respond within 7 days or later, the recovery proceedings can start. So what can be amended in R1A? I'm using a brief here for GSTR 1A. All the existing tables. R1A would be available after R1 has been filed, and it will remain available till filing of 3B. So we are not talking here about the dates. GSTR1 has to be filed by 11th. Let us say someone files it on 15th. So immediately after filing R1, R1A will become available. 3B is to be filed by 20th or 24th, different dates. And R1A will remain available till filing of 3B. So let us say 3B is not filed on 20th or 24th, or maybe it is filed next month. So till that time, it will remain available. It will get disabled only after 3B is filed. Like it has been said that it will be available for all the existing tables. So both the sections of GSTR1, we know there are two sections, add records, and there is a drop-down section now for amendment. So both these sections would be available, but a small catch here. When I was saying all the tables, it means all tables till table 13, including table 13 is for documents, etc. And table 12 is for HSN. So it is not only the liability implication tables, but the other tables, the HSN table, table 12, and the documents details table, table 13, they would also be available. Amendment of supplies declared in the same month only are to be allowed. So that means if there was a supply which was mentioned in an earlier period's GSTR1, that supply cannot be amended in R1A. The amendments in R1A would only be for the supplies which are mentioned in the relevant months or relevant periods R1. So quarterly filers' records can be amended in their quarterly GSTR1 for the concerned quarter. What is another feature which is allowed is that changing the supply from RCM to non-RCM. We know there is a checkbox available whenever we add invoices, is the supply liable to reverse charge. So clicking or unclicking of that checkbox would also be allowed. Change in recipient's GSTIN, however, will not be allowed. So this will remain a point that changing the GSTIN will not be allowed in GSTR 1A. Since GSTR 1A would be available only after filing of GSTR 1 until filing of 3B, there is no sequential filing. That means it is not required that like GSTR 1, a nil R1A has also to be filed for each period. So that is not mandatory. So no sequential filing. Since no sequential filing, no mandatory filing, there is no late fee also. But the look, feel, the uploading method, the generating summary, and all the validations which are there in GSTR 1, they will remain in GSTR 1A also. The records which are filed or saved would be available in 2A, 4A, 6A of the recipients. 2A is, we know, for regular suppliers, 4A for the composition taxpayers for their annual return, 6A for ISD, What is significant is here is saved records. So similar to the behavior of GSTR1, even if someone has uploaded a detail in GSTR1A, but not filed it, it will be reflected in the 2A, 4A or so. We have just mentioned these forms. We have not mentioned 2B here. So in which 2B would these amendments appear? Whatever is amended or added in GSTR1A will be shown in the next open 2B. So if we say a person is regular in filing, files GSTR1 on 11th of the month, by 11th of the month, GSTR1A becomes available. Before filing 3B, files GSTR1A. So what is the next open 2B? It will be next month's, because GSTR1's supplies are locked after 11. So it will be in next month. But if it is a delayed one, say somebody is filing GSTR1 after 3 months, then also the behavior will remain the same, that the R1A records, let us say somebody's GSTR1 for June 2024 is not filed till September 2024. Now this person files the GSTR1 in September, 1st of September, and by, let us say, 10th of September, files GSTR1A also. He has not filed yet the 3B for September month, for June month till 10th of September. So GSTR1A for June is available to amend. And if that person amends it on any record which was mentioned in GSTR1A, in GSTR1, in GSTR1A for the June month, which is available because 3B of June has not yet been filed, and this amendment through 1A is done on 10th of September, it will be reflected in September month's 2B, which will be generated on 14th of September for the recipient. So R1A records, same behavior as for R1, they will be shown in the next open 2B. The R1A records will be populated in R11 also. R11 is for the UIN numbers where they have to get the refund, etc. So when they generate their GSTR11, there also the records will get populated. They will also be added into the annual GSTR1, which we generate before filing GSTR9. There is a system generated annual GSTR1 available, so they will be added there also. These will be added in the comparison tables which are there for tax liabilities and ITC comparison. GSTR1A can be filed only once. So not only does it get disabled after filing of 3B, if somebody has just saved the records and not filed 3B, it is disabled. Now it cannot be filed. But if it has been filed, it will not be available again. So since, like I've just said, that GSTR1 is saved but not filed before filing 3B. So records amended in R1A, whether after filing or saved, cannot be amended in later R1. There is no IFFA for quarterly filers. For quarterly filers also, it will be only GSTR1A which would be available. So that was the one of the return forms which is coming very soon, GSTR1A. Malhotra sir, should we take up queries at the end only, or should we take it side by side? What do you suggest, sir?
As you feel right, sir, the way you feel.
Whatever you tell me that
there is a relevant query by
yes.
Mr. Gopal. Is not 14th and 15th also readable in 1A?
14th or 15th would be later. It will also come, but that will come later, sir.
So
in the first instance for GSTR1A, it will be only till tables 13. That will also come table 14 and 15, but they will come later.
Okay, sir. You continue, sir.
Okay, sir.
No,
yes,
Gurjit, sir, only one more thing. So there is one pertinent question by Himanshu ji, who is asking what is the purpose of this MME? As to what is the purpose of 1A? 1A, yeah.
So the purpose, like I said, currently whatever is difference between GSTR1 and 3B, the liabilities from GSTR1 get auto-populated in 3B. Let us talk of a scenario to understand this, that I entered a value as rupees 10 lakhs, one extra zero in my GSTR1, and it got filed. Now it can be amended only in next month's GSTR1. But my 3B, if I file it with a corrected value of only 1 lakh, there will be a report and a notice generated that liabilities short paid for 9 lakh rupees. I'll have to submit the replies to the officer with the documents, proof, etc. that why I have paid a lesser amount of tax. But if the officer does not agree or is not satisfied with my responses, the recoveries under Section 79 after the DRC 01D, etc., they can start. But if I get a chance to amend that 10 lakhs to 1 lakh before my GSTR 3B filing, I'll file the GSTR 1A with a correct 1 lakh, and my 3B will be auto-populated with 1 lakh. There will not be any difference between the GSTR 1 liabilities and GSTR 3B liabilities. So when we file GSTR 3B with the lesser values, all of us have known that whenever we change values, for liabilities, if we reduce the value, the tile changes to red color. So that won't be there. It will remain, it will not change to red. So that is the relevance, to provide an opportunity to the taxpayers to amend their entries which were filed earlier in GSTR1, but before filing 3B, all the amendments can be done. That is in brief the purpose of this.
Guljeet, this is Gaurav from Ahmedabad. I have a question here.
Yes, sir.
So the example that you gave, that, for example, the GSTR1 was filed mistakenly with 10 lakh rupees, and the filer realized before filing 3B and reduced it to 1 lakh. And in the earlier slides, you said that whatever impact of GSTR1A is there will appear in the next open GSTR2B. So if we go by the example which is under consideration, the recipient will be able to use ITC of 9 lakh for 1 month, even without government receiving that money, logically and legally.
So, sir, in fact, do you suggest that the recipient, without meeting the eligibility conditions of Section 16, should use the ITC of
Ideally not, but there will be no system generated trigger notice to him, because that 9 lakhs additional will be available to him. So that can go unnoticed to the department and can lead
that
to
is otherwise also available, no, sir? Even without GSTR1A, that is available.
I agree, sir, but then that was leading to a 9 lakh notice to the filer, to the supplier. Now that will go away, and the recipient will still have. So it's a double thing for the double-edged sword for the department per se.
No.
Sir,
Yes,
I will request your good self to kindly continue with the printing, and we will take question answer at the end, because time may be. And Mr. Khetan sir's answer after your session, you can continue with this, please.
Okay, Manoj.
Thank you, sir. Thank you.
So coming to the today, it was decided that we'll focus on the tables 14 and 15. So notification number 26 of 2022 issued on December 26, 2022. These two tables were added in GSTR1. And the intent of these tables is to capture the details of the supplies made through e-commerce, on which e-commerce operators are liable to collect TCS, and also where they have to pay liabilities under 9(5). So even this first part, that e-commerce operators where the TCS to be collected in the notified return forms, it was always existing there that those invoices should be recognized, but there was no method available. And 9(5) also, it was notified, some services were notified earlier also, for which the liability was on ECO to pay the tax, But after the restaurant services were added in 9.5, at that point, a claimor started that how it all should be reflected and how it all should be done. So it was subsequent to that, these tables 14 and 15 were there. The requirement to declare these supplies, the purpose of supplies through e-commerce operators where TCS is to be collected, that was for recognizing, for having the data where the TCS deducted and declaration by suppliers in their GSTR 3B, that matching can be done and it can be recognized from GSTR 1 itself, whether the TCS has also been properly collected or not. However, after these two new tables, so when new tables were added, 14 and 15, there were changes made in the all other tables also in table 4, 5, 7, 9, etc. The amendments tables, the basic tables, where there was the recognition of e-commerce, that was all that was amended. So these tables became available for January 2024 tax period, only 6 months old. So 14 and 15 in GSTR1 and IFF are relevant only for those persons who either supply through e-commerce operator. Here again, e-commerce operator only who is liable to collect TCS. If that e-commerce operator is not collecting payments on behalf of the supplier, like say I book a room on Make My Trip and I choose the option pay at hotel. If I pay at hotel, then TCS will not be deducted on that amount by Make My Trip. But if I choose the option of making payment through Make My Trip, then it will be deducted. So either supply through e-commerce operator where TCS is to be done, or where e-commerce operators themselves are liable to pay tax under 9.5. So table 14 is divided into two parts. The first part, which can be said as 14A, is liable to collect tax under section 52 TCS. Here the supplier has to report, not the e-commerce operator. The supplier who is supplying through such e-commerce operators, those supplies are to be added. These supplies are to be added as per the GSTIN wise summary of the supplies made. Liability on this has already been reported in tables 4 to 10. So the other tables of GSTR1 which are there where the supplier normally adds the invoices, their debit notes, credit notes, and the amendments for B2B or B2C, etc. Those invoices will continue to be reported there. But in addition, here in this table 14, it is not the document-wise detail even for B2B supplies. It is only the GSTIN-wise summary for those eco taxpayers which has to be made. Because these liabilities have already added in various tables, no taxable value or tax liability based on this table, the part A of the table 14 would be auto-populated to GSTR 3B. An amendment table for this has also been introduced, that is 14A. If we come to 14B, this is to be filed by those suppliers who are making supplies through 9.5. So supplies made through e-commerce operators on which e-commerce operators are liable to pay tax under 9.5. Here the summary details of supplies made through ECO on which ECO is liable. Tax on such supplies will be paid by e-commerce and not by the supplier. That means again, it will not be added in the liabilities of GSTR 3B. These values as the summary details are to be reported net of credit or debit note. We have just again said it is summary details. Even if it is a B2B supplies, invoice-wise details are not to be reported here. And the summary details which are populated here, they have to be net of the debit or credit notes. This I have already said that no liabilities will be auto-populated to 3B. But these values will be auto-populated in 3.1.1 second of GSTR 3B. For the previous one, we have not said that it will be added into 3.1.1. It is only the part B of 14 where liability is for 9.5 which gets auto-populated into 3B or it has to be reported. For this, the amendment table is 14A, again part B. Now, we just said that it has to be added into 3.1.1.2 of GSTR 3B. So let's have a quick look. What is that about? So in that GSTR 3B, details of supplies notified under 9.5, the supplier, any person, most commonly when, like I was saying, that this came into eminence when these restaurant services were added up to Swiggy and Zomato. It is the restaurant person, not the Swiggy or Zomato, who will report under this, because they are reporting under 14A, the restaurant people, and sorry, 14B, they are reporting. And in 3.1.1, part 2, it has to be reported. So taxable supplies made by registered persons through e-commerce operators. Why registered? Because unregistered persons, anyway, they are not going to file GSTR 3B. Only the total taxable value to be reported, because this is not affecting the tax liability. The tax liability is on the e-commerce operator. So the supplier has to report only the total taxable value. The fields for the taxes are grayed out. They are disabled in this table. And this gets auto-populated also from table 14B or the amendments table, the 14A table part B of GSTR. Going on to table 15, details of the supplies made through e-commerce operator on which ECO is liable. So table 14 is only for the suppliers. Part A for TCS, part B for supplies under 9.5. It is the table 15 of GSTR1, which is for e-commerce operators, for ECOs. It is not for suppliers. ECO will report the supplies on which they are liable to pay tax under 9.5. They are not to be reported anywhere else in GSTR1 or the IFF. For table 14, if they are required by the supplier, they are required to be reported anywhere else, they will be required to be reported, but not for part B. For part B, we are not saying they have to be reported in GSTR1 also, because if they are reported in other tables of GSTR1, then the liability will get added to 3B. So that is the distinction. We have not mentioned here that it has to be mentioned, it has to be reported in GSTR1. For 14A slide we have mentioned, 14B slide we are not mentioning. Coming back to the table 15. So e-commerce operator does not require to add such supplies anywhere else in GSTR1. They have to report such supplies only in table 15. And the e-commerce operator has to report these in 4 sections. So registered supplier and registered person, that is B2B. But there could be an unregistered supplier. The restaurant may be unregistered. Swiggy and Zomato may have made their guidelines that they will not onboard any unregistered restaurant, but it is being allowed. Latest changes have also been made there where the unregistered person can obtain a identity number, and based on that identity numbers, the e-commerce operators can verify that person. And so all that has also been added, but we are not going into that part right now. Unregistered supplier and registered recipient. So these are two parts where the recipient is registered. Supplier may be registered or supplier may be unregistered. Liability, the tax has to be paid by e-commerce operator and the recipient may be registered. What is the significance will come in a short while there. Next one would be where the recipients are unregistered. Supplier could be registered or supplier could be unregistered. So e-commerce operator has to declare into these 4 parts. Coming to the first part, where the supplier as well as the recipient are registered. So these are to be reported at invoice level. Whose invoice? Supplier is also registered. Just hold on to that query for a minute. This table would be available in IFF also. Debit or credit note have to be reported in 9B. So this comes an exception. The debit credit note has to be reported in 9B. Earlier I said that whatever is mentioned in table 15 is not to be reported anywhere else in GSTR1. Here we are saying that any debit or credit note for a registered supplier and registered recipient has to be reported in 9. Coming to where suppliers are unregistered but recipients are registered. Here also the document level details of the supplies made. So supplier is unregistered. In the previous part also we said whose document, whose invoice. Here also we are saying document level details. So whose document? Document from the unregistered supplier or otherwise. So these document detail should be included, and the GSTIN of the recipient should also be mentioned in that document. Only then it will go to the registered recipient. Again, it will be available in IFF. Similarly, even for this, the debit note or credit notes have to be reported in table 9B. Coming to the next parts where the recipient is unregistered, and in both these cases, supplier level details along with POS and rate-wise details. So it is similar to the B2C supplies part of GSTR1 that we have just to declare for each POS, the rate-wise details and total amounts. This is not available in IFF. So only the part in IFF we know. In IFF, only those parts are available where the credit flows. So that indicates that where the recipients are registered, the supplier may be registered or unregistered, but those parts are available in IFF. But where the recipient is unregistered, they are not available in IFF. Here, the debit or credit notes for both these are not to be reported in 9B. Just the supplies have to be reported net. And these supplies can be negative also. Obviously, if there is a credit note which is of a larger amount than the current period's supplies, it can be a negative amount. Though that will be rare, but it can be a negative amount. Proceeding further, taxable value with tax liabilities from all these four sections, which we have just talked about, will be populated in 3.1, point number 1, or the part 1. For table 14, they were getting populated into part 2. This is a later table, but it will get uploaded or added in 3B's, the relevant tables, the first point. These liabilities to be paid by ECOs in cash. So this was added in the circular which was issued. The significance is that since these are restaurant supplies, logically they are not allowed to avail the ITC. So it is the same liability which is getting shifted onto the e-commerce operators. So even they should not be allowed to use their ITC. That is why it is being said that though the liability has got shifted onto e-commerce operators, they can't use their ITC available, maybe due to any other inputs, but they have to pay this in cash. For registered recipients, there is a checkbox is available for selection of type of taxpayers. We said earlier, if you remember, that for registered recipients, their GSTIN has to be mentioned. Those details are to be mentioned invoice-wise, and there is a checkbox. There could be that the supply is as a deemed export supply, or this supply is as an IGST supply to an SEZ with or without payments. Amendments, relevant table 15A, 1 or 2. These are there. Details of the documents issued by ECO. So we were on the part that whose documents. Supplier may be registered or supplier may be unregistered. The recipient is registered. In those cases, invoice-wise details have to be given. So whose invoice? It will be the documents issued by the e-commerce operator if recipient is registered. It is the e-commerce operators who have to issue the invoices. So we should be very clear about it. It is not the supplier's invoice which is to be declared here. It is that means e-commerce operators, they have to generate their invoices and they have to declare the values and the taxes here, and it will be their documents and document details, the number and date which is to appear. The details added in table 15 for registered recipients, because their GSTIN is there, the ITC has to flow if it is available. For restaurants, it will not be available, but if it is available, even for restaurant in certain circumstances it may be available, they will flow to 2A, 2B, 4A, 6A, and GSTR 11 for this. There will be no auto population of e-invoice in table 15. So after this part, when we are saying that it is the invoice of the e-commerce operator which has to be, they have to issue the invoices. So if that e-commerce operator is liable for e-invoicing, will those invoices get populated into table 15? So as of now, answer is no. But if they are liable to generate e-invoices, that means they'll have to generate e-invoices. There is no exception for 9(5) liabilities. Then the e-invoices reported for supplies to registered recipients, they have to be added into the table 15. But since they would be available in the auto-generated there, the e-commerce operator, there is an added responsibility on them to verify that those invoices are not included in any other table. But they have to auto-populate, not auto-populate, they have to populate on their own in table 15, even though e-invoices have been checked. Let's have a look again to the relevant portion of the GSTR 3B, 3.1 part first. So details of supplies, this table is for detail of supplies notified under section 95. These are the taxable supplies on which liability is on e-commerce operator under 9(5). Here the total taxable value and the relevant tax amount, IGST, CGST, SGST or cess has to be reported and auto-populated from table 15 or the amendment table 15. So in this table of GSTR 3B, auto-population is there. But again, just mentioning here that when auto-population happens, the edit facility is available while filing 3. Some points. This is sort of a, okay, this is a slide has been added twice somehow. So coming to the amendment tables, we just mentioned briefly that there are amendments tables available 14A and 15A. So these are available to capture the details. Significantly, they are available from February 2024. So table 14 and 15 were available from January 2024. Amendments can be carried out only in the next GSTR1. So in the subsequent GSTR1 for February 2024, the amendment tables also became available. So that means it is obvious that these tables are for those taxpayers who have reported supplies in table 14 or 15 in the earlier taxpayer periods. So table 14A, supplier can amend the details of original supplies already reported. Again in two sections, part A, liability to collect TCS, and part B, liability to pay tax on e-commerce under section 65. The amended values will be auto-populated only from part B. This will not be because the liability is not there. This is liable. These are again already entered in other tables of GSTR1. So from this part, similar to table 14, there is no auto-population into 3B. It is only from the B part where the liability is on there, that auto-population in part 2, which does not add to the liability, only the total taxable values get auto-populated, no tax amounts. 15A, e-commerce operator can amend, because that is to be, 15 is to be filled up by e-commerce operator amendments. Again, all those four parts, the recipient could registered, but supplier is registered or unregistered. Recipient is unregistered, supplier could be registered or unregistered. So amended taxable values along with tax liabilities from all these sections, they will get auto-populated. The liability remains on e-commerce to pay taxes for all these four parts. It is only that the ITC will flow only for these parts. So e-commerce operator to report amendment of debit or credit notes in existing table 9C. Since debit credit notes by e-commerce operators for supplies related, which are mentioned in table 15, they have to be reported in 9B. So amendments also correspondingly in table 9C, not in this part for debit credit note. Now we come to the that is the completion for the table 14 and 15 part. There's one more recent thing which has become available. That is auto population of the HSN details in table 12. That has been implemented. So how does it get auto-populated? It gets auto-populated from e-invoices. That means auto-population will be only for those suppliers who raise e-invoices. It can't be possible for other persons because in the invoice level tables or the tables we are not mentioning the HSNs. So that data is not available in GSTR1. It cannot be auto-populated into 12. But since this HSN-wise data is available in e-invoices, for such persons from the e-invoices, the details of HSN-wise can be downloaded or made available. What can the taxpayer do? They can download the HSN details from e-invoice in Excel, or they can import the data and auto draft it into table 12. So if the taxpayer chooses only this option, then it will not get auto-populated. If they import this, they can. Whatever data is imported or which is made available in table 12, taxpayer can view them. Obviously, they can also edit or delete the details. So how does system do it? System computes HSN-wise summary of all e-invoices from the IRPs. Here the plural of IRP is very significant. We now know that there are 6 different e-invoice dashboards which are available, and taxpayer is independent to report their e-invoices in any of the IRPs. In any of the IRPs, wherever they are uploaded, they will be collated and a summary of HSN will be formulated into table 12. Download is available, but import is also available, like said earlier. So how is download available? In the existing download, there is already in GSTR1, when we try to file, there is a tab available, download details from e-invoices. So when those details are downloaded, the HSN summary is also now added here. But if the import data is used, then the details of table 12, all the details, all the HSNs, there could be multiples, 10, 50, 100 different type of HSNs. So all different HSNs, their respective quantity, their UQC, unique quantity code, their values, rate, and taxes get auto-populated. How these will get populated for multiple? They will be captured from the documents, but based on the document date. This is again significant. We know that as of now, it is not mandatory. There are instances where an invoice of a particular date is uploaded or added as an e-invoice at a later date. So the details which are captured for auto-population are based on the document date, not the IRN date. Not the IRN date. So if any document, let us say, is dated 31st May, but e-invoice is generated on 4th June. So in table 12, the detail will be auto-populated based on the document date, not the IRN date. So this is again an important point which needs to be. So there are only 10 minutes remaining, and there are not many slides which are there. But talking about the today, again, वो वाला आज जो अभी चल रहा है, let's have a look at few points, which is the view from the other side. The view from the other side means that we have been talking only about the taxpayer sides. Let's talk about the officers' side. So officers have been made available the features or functionalities to view the monthly summary of GSTR1 in Excel. They can also view or download the GSTR3B in Excel. they can download GSTR 1 annual summary or 3B annual summary in Excel or for any specific tax period. If officer wishes to view any taxpayers GSTR1 in Excel for 2, 3, or maybe 6 or 8 months, any period they can select and they can get a single Excel sheet also, besides the monthly and the annually also. What is the most important part here is that which we must know, because we have to go to the offices, there are various notices, etc., to which we have to respond, that the invoice-wise details of GSTR1 are also now available to the offices. Earlier, for the taxpayers, even now what we can view is only the recipient-wise summary, not the invoice-wise details. But the officers can now view the invoice-wise details also of GSTR1. They can have an Excel for it. And the details of e-invoice, whatever e-invoice is generated by a person, based on that, what should be the GSTR1, a system-generated GSTR1 that is available. And also, when we were talking about the GSTR1A form, we were saying that they get auto-populated into 3B. And every month we see that we have a system-generated 3B also. So this system-generated 3B is also available to the officers. Officers can also view the filed GSTR 3B as well as the system-generated 3B. So this is the view from the other side. I believe that I'm sure that there are some points here which are of much relevance for all of us as practitioners to know that officers have all these details up. Lastly, we talk about the Kal Gujra Hua, the yesterday. Here, not much, but only one point which I am mentioning here because there were a lot of discussions about it, and this was something very unique and unusual which happened. This was the reset and refiling of GSTR 3B for some taxpayers. You may remember that the facility for filing or refiling of the old GSTR 3B was made available for some of the taxpayers some time back, about 4 months back, if I remember correctly. So why did this happen? This happened because in the system, there were some discrepancies for some taxpayers where the data saved in the GST system and the actually filed data, there were differences. If we generate the 3B of any tax period and the data which is available in GST system itself, there were differences in the ITC as well as the liabilities. So these led to much trouble for certain taxpayers, and grievances, etc., were raised. So grievance redressal committee decided that such taxpayers should be allowed to reset their 3B. And opportunity was provided to taxpayers to correct their discrepancies. Only the affected taxpayers were communicated. So whether all the affected taxpayers got communicated or only those affected taxpayers who raised their queries to a grievance redressal committee, the effort was that all such affected taxpayers should be given this opportunity. Just adding that, why did this happen? We know that in GSTR 3B, there are different steps to save the data, confirm the data. Earlier, there used to be buttons to submit and then maybe filing. Sometimes even the liabilities are offset, but GSTR 3B is not filed simultaneously. There could be significant time period gap between saving or computing the liabilities and setting off the liabilities or filing of it. At different stages, there could be certain time gaps. So because only in cases where there were such time gaps, sometimes in the GST data, there was only the saved data or the older data which remained. And finally, while taxpayer was filing the GSTR 3B, the figures were something else. That was the reason why it got generated. But that reset was made available. That was the last point here. I hope I am in time. Thanks, everyone.
Thank you very much, sir, for being in time, sir. No question answer session will be there. Any query is most welcome, sir.
Yes, Malhotra sir.
Arup sir, there is no query I wish. So I request Mr. C.A. Venugopal ji to give the formal vote of thanks to both the speakers. Thank you.
So
Venuji.
Venugopal ji, before you go for the vote of thanks, there is no query. That means everyone has understood, or everyone already knew whatever was presented.
I think, sir, the way you have presented, it was lucid. It was easy for us to grasp. Not only the presentation, but also
Sir,
the
there are some
momentum.
queries in the chat.
Yes, there are some queries. Yeah, Venuji, can you read the query? Or Malhotra
Yeah.
sir?
I will read the queries, no problem. First question, अगर 3B late हो गया, so can 1A be filed before the 3B?
Yes, that is what I mentioned it earlier also. 3B late हो गया, जितना भी late हो जाए. Till the time 3B is filed, 1A will be open. There is no deadline for 1A. There are no date lines or timelines for 1A. Only timelines are it will be available after filing of GSTR 1. Even if it is filed earlier, let us say on the 1st of month it is filed, 1A will get available immediately. And it will be available till 3B is filed, earlier or later.
Okay. Good. Next, the values to be entered in 1A is the revised value and not the delta. Is the understanding correct?
Yes, sir. It will be in 3B, only the revised value will come.
Sir, only that month's invoice can be included, sir, or previous months. Only that.
The amendment part, I'm very sure that it can be done only for the records which were in there. But about adding part, I'm not 100% sure as yet. I think we'll have to wait for it. Because in GSTR1, earlier missed invoices also can be added. So I don't think there will be a validation of verifying that date. But when we do amendments, there is a validation of there. But for amendments, also we are very sure that it will be there. But let it come out about the missed invoices being added.
And the another point is if April month invoice, can it be amended in 1A of June, or it should be amended in the June R1?
So question is that invoice of April, can it be amended in June? So if that invoice of April was declared in GSTR1 of April already filed, then it cannot be amended there. But we know that in GSTR1 of June, we can add an invoice of April also. So if that is the scenario, then it can be amended in GSTR1A of June also. But not if it has already been added in.
The supplies are made through e-commerce operator, and these are not taxable supplies. Should that also be reported into table 14? These are forming parts of table 8 of R1. Should it also be coming into table 14?
Yeah, but are there? We didn't talk about these details. I think I missed out that slide. I decided that I'll just to add that slide about 9.5 liabilities. There are 4 kind of supplies there, which are the cab services, etc., motor level, motor vehicle, omnibus was also added. Then the housekeeping services, the accommodation services, and lastly the restaurant services. So whether the amended supply, exempted supply. So for exempted supplies, there is no liability on e-commerce operator to pay. So I don't believe they have to be added. It is only where the liability is there, only those have to be added there.
Got it. Next question is on the e-invoice reporting. For a transaction where it is a 95 supplies, e-invoice shall be done by the e-commerce operator. Is that
right, sir?
And what should be the content of the original supplier's invoice to e-commerce operator?
If that supplier is registered, they have to follow whatever there is in section 31 and the relevant rules. All those details would have to be there because the original supplier has to mention all those details in their invoice. They have to
Because
follow all those details.
to the end customer, the invoice is being issued by the e-commerce operator and not the original supplier.
Yes, sir.
So, so the original supplier will issue a bill of supply to the e-commerce operator.
Yeah, it will not be a tax invoice, but yes, the invoice, the tax invoice in the sense that the liability is not there. But if there is tax involved, etc., all those details have to be mentioned there. Even the tax rate and details, etc., for that part have to be mentioned in the invoice.
Okay.
But
Then
it will
there
not be
be a
declared in
provision
the.
for amending I got it.
Sorry, sir.
So question from Sharona Kumar sir. Can table 8 be also be amended in 1A?
Table 8.
Yeah, exempt supplies.
Yes, yes, yes. All the tables till table 13. All these tables
Yeah.
are available.
Yeah, I guess all the questions we have addressed, sir, and we are
There is one question
short
I
on
need
time,
to ask.
11 o'clock. Yes,
Only
Praveen.
all the tables
Venu-
except table and 14 and 15, which was Venu sir's query at the beginning itself. So table 14 and 15 will be added in GSTR 1A a little later. Once the table up to table 13 comes into effect, then it will they will be in the second part of it. They will be added there. Yes, sir. Please.
Sir, is there any plan to discontinue with GSTR 3B? Do you have any idea or discussion?
Sir, we can't be sure till it happens. All of us have had the experience of the new returns. We have had so much learning and so much discussions, formats, etc. were also out. So till it actually happens, we can't say anything with confirmation.
And is there this this amendment which they are talking to allow for only few days? Can it be extended to infinite time as it is being done in TDS income tax?
The amendment of which amendment are you
correction.
particularly?
Correction.
1A. So 1A.
1A, otherwise, sir, the GSTR 1 of subsequent month is already available for amending the earlier supplies.
No,
There
but
is
sir,
no such need.
It is ultimately restricted till September, no?
Yeah, that is there. Till September or November, that whatever is there.
Yeah, I am asking a question as we are allowed to amend TDS entries under income tax for infinite period. I can do the
Yes.
amendment of 10 years back also. Is
Yes,
there
yes.
any
So,
talk to allow to amend any entries for post the restriction period also?
so nothing which I am aware of as of now, sir.
Okay. Thank you.
All right. So at the outset, I think we should thank both the speakers, Naveen sir and Gurjit sir, who have enlightened us with their wisdom. And at the beginning, Arupji was clearly mentioning that this SMS is for us, and Gurjit sir also has highlighted. So there is a continuous effort that we do the SMS and our faculty members take up a topic, and it's actually every time when an SMS happens, we have a privilege to read the section with a new perspective. And some of the points which we discussed on section 15 are also have come up in the circular. I think the SMS is really a great opportunity, and we've been ensuring that we start at 9 and complete at 10. I thank all the speakers and thank all the participants for joining us, and especially Gurjit sir, GST के साथ साथ आप भी हमारे साथ साथ हैं, and that is more important. And your wisdom, your words weigh a lot in the discussion. Thank you so much for your time, sir. And Naveen sir, thank you very much for bringing the GST tribunal related perspective, and most of the faculty members who are here are eagerly looking at taking up these matters to the tribunal. And in the due course, we would also request more sessions from you too. Thank you very much for being
Thank you.
today with us, sir.
Honored
sir.
and obliged, everyone. sir.
Thank you, everyone.
Colleagues.
And thanks to Malhotra sir also for being the wonderful coordinator. I think, moderator for the day today. So thanks, Malhotra sir. So I think it is indeed wonderful that we had the wonderful moderation. So thank you, everyone.